And may I now invite Mr. Jethmalani to come to that.
First of all, I must thank the foundation, the Justice Tripathi Foundation, for bestowing this honor and having me as a member of the panel today. This is really payback time because I went to Chhattisgarh just before COVID, and he was the Chief Justice serving there, Justice Tripathi. And I must say, going to Chhattisgarh, when you go to the court, you have to go to a place called Bilaspur. So you get off at Raipur, and then you take a 4.5-hour drive in those days, Bilaspur. The roads were pretty wretched in those days. But with each trip and I went there very often, with each trip to the Bilaspur High Court, I found myself getting more and more eager because Chief Justice Ajay Tripathi was the presiding judge in most of the matters I did there. I mean, they were all political matters, as happens often in India. The old state government went out, the new state government came in, and persecutions began. So I was there defending the old regime and sometimes, hitting back at the new regime as well. But he was a great judge. He was the most courteous of judges. And I have to say that Bilaspur became extremely convivial on account of my many interactions with him as a lawyer before an extremely fine judge, one of the finest judges I've had the privilege of appearing before. And I thought Justice Tripathi would be bestowed the honor of becoming a Supreme Court judge, and he was headed there. There's a lot of talk about him becoming a judge of the Supreme Court. But I was a little surprised when he actually chose to go to become the Lok Ayuk and eschewed judicial service. One last thing I must point out is that when my father passed away in 2019, Justice Tripathi, Chief Justice Tripathi, was one of the earliest visitors to condole with the family at the time. A courtesy which I with the greatest respect because of all the great interactions I had with him. I could not pay back because when he passed away, it was COVID, and I had moved to be with my family in Bombay. And because of the travel restrictions, I couldn't attend his cremation. It's one of my deepest regrets. And of course, I've since met the family, and they have in their own way made up for it. Mrs. Tripathi, Aditi, of course, I'm constantly in touch with. And of course, I've had the pleasure of meeting the two other girls today, and I hope I continue this long association with the family. That's about Justice Tripathi. Thank you, the foundation, for inviting me for this trialogue. It actually should be called a quadrilogue because Shahrukh is very much there. In fact, she's moderating and steering this. So this is, in effect, she's going to put us on course every time we go off course. So this is really a quadrilogue. And it's a great pleasure to be moderated by you.
Thank you very much.
Now, coming to the topic of the day, separation of powers. So the doctrine of separation of powers found its most robust and passionate exposition in the 18th century in a treatise written by the famous French political philosopher and actually man of many parts, Montesquieu, in his book entitled The Spirit de Loi, i.e. the spirits of the laws. In his pristine formulation, in a nutshell, good governance and absence of tyranny could only be achieved if the executive, the legislative, and judicial powers vested in three distinct bodies as opposed to being vested in only one body. In its simplest form, that in a nutshell was what he was inspired by John Locke and others at the time, but in its simplest form, in its most pristine form, that was the doctrine. Montesquieu's theory on separation of powers, however, finds no place in the Indian Constitution. Although it may be noted that one judge in the Keshavananda Bharati case considered it to be a basic feature of the Constitution. While it was mooted during Constituent Assembly debates, amongst others by Professor K.T. Shah, it was emphatically rejected by the Assembly, most notably by the drafting committee chairman, Dr. Ambedkar. According to him, while the executive should be separated from the judiciary, in the parliamentary system of government which India adopted, good governance entailed harmony between the executive and the legislature, and the Americans who had adopted the separation of powers doctrine were themselves dissatisfied with its functioning in practice. Now, the Indian Constitution vests vast powers in the high courts of the states and the Supreme Court at the apex of the judicial system, granting them the power of judicial review over executive actions under 226 and Article 32 of the Constitution, respectively. Article 32, which enables citizens to move the Supreme Court for enforcement of fundamental rights, is itself a fundamental right. While judges were to be appointed originally by the executive in consultation with the judiciary, their removal could only be effected through the arduous legislative procedure of impeachment, a process that persists to this day but is rarely invoked. What is the post-independence reality in India regarding the doctrine of separation of powers? During the early years of independence, with socialism as a prevailing ideology and a polity consisting of a one-party dominant system, the judiciary worked harmoniously with the government of the day, upholding its various socialist measures such as land reforms, bank nationalization, and the abolition of privy purses. A defining moment arose with the declaration of emergency. The stark abuse of power during that period highlighted the need for an independent judiciary. Post-emergency, the authors of the ADM Jabalpur judgment, which upheld the fraudulent emergency, were vilified. One of them, the late Justice Baibi Chandrachud, apologized for his decision. Another judge, Justice Bhagwati, became a champion of liberty through his judgments thereafter. And the dissenting judge, H.R. Khanna, became synonymous with judicial courage and ensured that his legacy would be revered by future generations. The high courts of the country, however, covered themselves with glory by releasing thousands of illegally detained prisoners of conscience through habeas corpus writs. The independence of the judiciary became the new byword, and in the new climate, the judiciary asserted both its independence and power. Procedure established by law under Article 21 was replaced with the American concept of due process. The frontiers of Articles 14 and 19 were expanded from time to time, and most significantly, the judiciary itself, in 3 constitutional bench judgments, established the right to appoint judges both to the high courts and to itself by a deft interpretation of the phrase consultation with the Chief Justice as concurrence with the Chief Justice. The primacy in appointment of judges thus vested with the Chief Justice, which gradually evolved into the collegiate system, by which the 5 senior-most judges of the Supreme Court were the last word in the appointment of judges. One last attempt by the executive to restore its primacy in the matter of appointment of judges by the creation of the NJAC, the National Judicial Academy, as the Supreme Court for the appointment of judges by the 99th Amendment to the Constitution, was rejected by the Apex Court in 2015 by a 4-1 majority in the Advocates on Record Association case. Henceforth, Article 50 of the Directive Principles, which envisaged the separation of the executive from the judiciary, was now fully consummated. Now, that's so far as the...
Sir, only because I interrupted Ambassador Varma. There are about 2 minutes.
Yes, and I'm almost... I'll take even less time than Mr. Varma did in his extended time. And you don't have to have such parity, it's okay. But I'm flattered I'm being put on par with Mr. Varma. On the other hand, real legislative power has never vested in the Indian Parliament except nominally. Parliament is not sovereign under the Indian Constitution. Indeed, even in UK, the notion parliamentary sovereignty was a misnomer. As the constitutional expert Sir Walter Bejo observed, The cabinet in the UK is the belt that fastens the executive to the legislature. In other words, the parliament system of government was always government by the cabinet. Bills which are laid on the floor of each house of parliament are prepared and tabled by the concerned ministry, and their passage to the legislature is piloted by the minister concerned. A 3-line whip ensures voting compliance of a legislator on any bill which the government of the day is intent on passing. And by the 10th schedule, failure to comply with the whip can now lead to disqualification of a dissenting legislator. In truth, ruling party legislators are bound to the government of the day. It is only the opposition MPs who in reality can oppose government legislation, a task which in more recent times is discharged with sloganeering and disruptions of the House rather than informed debate and discussion. The most efficacious work in Parliament is performed in the various parliamentary committees that exist. I'm almost done before you interrupt me. In sum, given the complexities of a modern day state and the nature of governance in contemporary times, the pristine form of government of separation of powers prescribed by Montesquieu is both impractical and non-existent. Even in the US, where real separation of powers is in theory supposed to infuse the 3 wings of the government, the doctrine is a recipe for non-governance or simply not an example of the doctrine in practice. There is gridlock in Congress on the one hand, and there is gridlock between the President and the Congress on the other. Moreover, the process of appointment to the Supreme Court by the President and the subsequent confirmation process by Congress has led, depending on the party to which the President belongs and which party controls Congress, to what is known as Republican courts and Democratic courts. So, ladies and gentlemen, I end by saying that while Montesquieu and his separation of powers theory really doesn't exist in any country, Montesquieu and his theory of separation of powers is important because it has given rise to the system of checks and balances, which is a part of the governance system in every constitutional democracy, or indeed any democracy in the world. Thank you, ladies and gentlemen.
Thank you. Thank you.